Hey out there, legal warriors. Did you know there's something called a restraining order that can help protect you, that can help make you feel safe again? And recently it got a lot easier in Washington State to get a restraining order. If you're interested in this area of the law, stay tuned because this is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. Now I'm just going to jump right into it. Restraining orders. There was recently a big change to the restraining order law under RCW 7.105 to put all these different types of restraining orders in Washington State into one statute, one section of the law, basically, one chapter. And it got even easier for somebody who wants to try to get protection from another person to get an order from the court that you might call a restraining order. The law calls it a protection order. An order from the court that stops that other person from talking to you or being near you, things like that. And so in this video, I'm just going to cover what are some types of restraining orders that exist and basically what the process is and how you go about getting one. So again, the first thing, take a look at RCW's chapter 7.105. It's pretty self-explanatory, but I'll go over some of the restraining orders available. There are restraining orders for domestic violence. If you've been a victim of domestic violence, and they really broaden that the language that defines domestic violence. Basically, if you've ever been afraid of someone that you've dated or lived with or is a relative of a certain type, you've been afraid of them, even if they didn't actually physically harm you, you may be able to get a restraining order. There's anti-harassment orders. You've got that neighbor who's always yelling at you or scaring you or just going out of their way to make your life miserable, to inflict emotional distress on you that's not legitimate, and your emotional distress is reasonable, then you may be able to get a restraining order. There's stalking also. There's someone who's been following you, or a boyfriend that won't leave you alone though they never did any domestic violence. Well, you may be able to get a stalking order against them. There's also sexual assault protection orders. If, God forbid, something happens where you're assaulted in a sexual way, there's some very broad and strong orders you can petition for under RCW 7.105 to try to get protection. There's also a vulnerable adult protection order, someone that is being taken advantage of by someone, by a worker or by a relative is taking advantage of them, or abusing them or not taking care of them. You may be able to get an order that stops that from going on, although you may want to deal with adult protective services there first. And so these are some of the types of orders, not all of them, that you can get underneath this statute. So who needs these orders? Well, you may need the order if you're afraid or you're fed up and you think that the conflict being escalated, the risk of the conflict being escalated by attempting to get the order is worth it. And so if you fall into that category, how do you get an order? Well, you can get an attorney to help get an order for you, but it's also designed for you to try to do without an attorney. So the first thing you're going to do is read the statute and then think about what jurisdiction, the place that you live or the place where the problem happened. And then I would go to the court's website for that jurisdiction. I do know if you're in King County, you can go to the King County District Court website, and they have some really good forms. They have the petition available right there online that you fill out about why it is that you're in need of an order. They've got all the paperwork you would need right there. Now, the district court is empowered to hear cases that don't involve the custody of children and don't involve excluding people from residences. If a case involves the custody of children or excluding people from a residence, it will eventually end up in Superior Court, so you might want to start filing it right in Superior Court. You're still allowed to file it in a district court, which is a lower level court, but they're going to transfer it to the Superior Court anyway. So, petition, what's that mean, Lance? Well, the person who's requesting an order is called the petitioner, and the person who the petitioner is seeking to restrain is called the respondent. And so in Washington State, the petitioner is able to ask for a temporary emergency protection order. That's what they're called legally. I'm calling it restraining. They're allowed to petition for a temporary emergency restraining order that the respondent has no notice of. And so how you do that is you fill out that petition, and then you follow the court's instructions for filing it. Many of the courts now have ways to electronically file it, and if you can't electronically file it, you could print it out and bring it down to the court. And so you have to swear under penalty of perjury that certain things are true. The form is going to ask you to identify the respondent. There's going to be a law enforcement information sheet you need to fill out that identifies the respondent, identifies yourself. That's kept confidential. It's not given to the respondent. And it's going to ask you to write out what's happened and what it is that has went on. What's the most recent event that happened? What are other events that happened? And what do you want? You have to check what you want. Do you want them restrained from your school, from your residence, from so many feet of you, from your home, from your child? Yes, you are able to petition on behalf of your minor child in this state. And you're going to need to fill out, hey, do you want them to have to turn in any firearms to the police? Do they have firearms? Things like that. And so it's very user-friendly, but it's very long. So it's easier to understand, but maybe it's not as user-friendly due to the length. It's very long, but they're trying to make it clear so you're able to do it on your own. And once you're done filling it out, you turn it in, and then a judge looks at it without any notice to the respondent. The judge looks at it, and if the judge says, hey, what is written here, if it's true, falls under one of the statutes that allow for those different types of orders, then I'm going to issue an emergency temporary order that's good for 14 days. And I'm going to set a hearing for 14 days from now. Could be a day longer if there's a holiday in 14 days or a weekend, stuff like that. But 2 weeks, I'm going to set a court hearing for 2 weeks later, and I'm going to restrain the respondent. Typically, they can't issue it without a restraint, but typically I'm going to restrain the respondent. An order is going to go into place for 2 weeks, and the respondent gets a chance to show up in court and say it isn't so, or say their side of things, because we're entitled to due process, right? The respondent is entitled to their day in court. And so if the restraining order takes away firearms from the respondent temporarily, then law enforcement is typically ordered to serve the respondent, because law enforcement needs to go there and get the firearms also, right? If it doesn't restrain firearms, or the court can also just choose to do things differently, but then they may require you to have the respondent served with the petition for the protection order, what you wrote that entitled you to the temporary order, and also the notice and actually the order itself, the temporary order that restrains them and gives them notice of the hearing. They are not restrained until they know about the order, so that's why they have to be served. They also have to be served so they have a chance to respond, due process. Now, if the court is not having the police serve it and the court wants you to serve it, you are not allowed to serve it yourself as a party in the case. Some other adult who is not a party in the case needs to serve it. It could be a friend of yours. You could hire a process server to serve it. They're usually inexpensive, think $100 or less. And then that packet of materials needs to be served on the respondent a week before the hearing. It's 5 court days, so if there's a holiday, it might need 8 days before the hearing, but a week before the hearing, because we don't count weekends when we count these things, okay? So 5 court days before the hearing, they need to get the packet. If you don't get them served, or they don't have the packet in time, then there's some things that are going to happen in court. You're going to go to court on your court date. You may ask for a continuance. The temporary order may get extended. But basically, you file the petition, the court grants a temporary order, somehow the respondent gets served, then the respondent gets a chance to go to court, and you have to go to court on that new court date, which is again 2 weeks after the temporary order. What to expect at that date? Well, the respondent gets a chance to fill out their own affidavit about why it's not true and why you're the problem, right? Why you're the one who should be restrained, or you're a liar, or whatever, right? They're going to write. Oftentimes the respondent is going to show up and ask for a continuance to try to get more time. That's routinely going to be granted. The good news for you as the petitioner is that if that continuance is granted, if you had protections, those protections will continue typically until the next hearing. Now, the respondent gets that chance to file a response, and they're supposed to serve that on you, because you get to see what they write, And then you as the petitioner, because you have the burden of proof to prove that you've satisfied what's in the statute by a preponderance of the evidence to be granted the order, you get the final word. You can write a reply. And again, that reply needs to be served on the respondent prior to the court hearing, filed with the court ahead of time, and served on the respondent. So once there's been the petition and the response and the reply, then the court can hear more testimony if they want, from the parties. Some courts want sworn testimony. Some courts just want to hear argument and read the declarations. Then the court will make a decision. The court can grant the order or deny the order. The court grants the order. Sometimes they can award costs to the petitioner for the cost of bringing the action. That's not very routine. They cannot award costs to the respondent under the statute. In very limited circumstances, the court can reverse the designations, turn the petitioner into respondent, respondent into petitioner. Don't see that happen very often. And the court can issue the order for any amount of time it wants, from forever down to a few days. The typical length of an initial order is a year that I see if one is granted. So that is the process if you want to try to get protection. So what should you write? What should you put in your petition? Well, you want to put what happened, and you want to put how it's affected you. And if you have evidence, you want to put text messages or emails or things in like that. But you need to tell the emotionally true story of what you've been through, so the court has an ability to understand it. Because let's remember, when we're writing a bunch of long stuff, the court, the judicial official, is just a person who has a certain amount of capacity to sort through all this. You've got to make it clear for them about what's going on. They're not going to work to see your side of things. They're hopefully neutral, and they're going to do their best, but you're not the only case they have on. What if they have on 15 cases to do in 90 minutes? If you have a rambling, long petition that is, 100 pages that they have to sort through, they may just tune out and you're not going to get what you want. So you need to make it clear, declarative statements at the beginning of sentences, a follow-up after the declarative statement about the supporting evidence for that statement, those type of things. And so again, it's designed to do yourself, but if you need help doing it, there are plenty of attorneys, including my firm, who does handle protection orders both from the petitioner side and the respondent side. So there's all types of ways you can get that protection. If you have the protection and there's been an order issued, what happens if the respondent violates the order? Well, if you call the police and the police believe the respondent's violated the order, they will likely arrest the respondent and charge them with a crime. And so it's real, the protection is real. It's a civil matter, it's not a criminal matter. It's sort of a lawsuit between two people. But if that order is granted and that order is violated, then it turns into a criminal matter where a prosecutor will prosecute the respondent for violating the order that you got in the civil hearing that you requested. So it's a very potent area of the law. It's very interesting, and it's very powerful if you need help. So if you found this useful, please like and please subscribe. More people get the help they need. More importantly, if you need some help with a protection order, restraining order, please give my office a call. We've been doing this for more than 20 years. We'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.